thank you for joining. Hopefully everybody can see the slides. If you can't, or if you have any questions or comments, please feel free to use the chat box as part of the meeting chat. You can also raise your hand if you feel as though you need to interject something, but we'll try to get to as many questions as possible. We only have an hour, so let's get underway and we'll see how far we get in terms of being able to answer questions and cover all the material. So this is a Data Protection Law 2020 update specifically on Part 4 of the new Data Protection Law, which is around data transfers and sharing. So it's Articles 26, 27, and 28 of Data Protection Law 2020. It's maybe a bit out of order to jump right into the data export part of the law, but there's a reason that we started with this one now rather than going back to accountability or some other sections that come before this. And the reason is this: we planned it such that we were anticipating the Schrems II decision, which came out of the Court of Justice of the European Union about a week and a half ago on July 16th. And we'll get to that later. We're not going to discuss it up front, but we will talk about it briefly towards the end. But it does have an impact on data export out of the DIFC to Europe and potentially from Europe to the United States and other jurisdictions as well. So we wanted to have this webinar in a sort of timely way and associated with the issues that are really predominating the headlines in data protection globally right now. And that is indeed one of them: data export, transfers overseas, and the use of certain mechanisms such as privacy shield and model clauses and whatnot. So all these things, if you haven't heard of them ever before, we'll talk about again briefly. If you have heard of them, hopefully you are on the same page and are anticipating hopefully some information about that decision, I should say. So what I'm going to start with is covering again the DIFC Data Protection Law 2020 versus 2007. I don't want to spend a lot of time on this. If you've seen our presentations before, you've probably seen this very same table, and I'm reiterating it here for consistency because these are really the key points and updates between the previous law, the 2007 law, and the current law, which came into effect July 1st. I've highlighted here, obviously, the topic that we're talking about, though, international transfers. We realigned the international transfers section to comport with current international adequacy standards, making processors more accountable, adding in recognition or detailing specific transfer mechanisms that were not present in the Data Protection Law of 2007. Just so that it's really clear exactly what we will and won't accept when it comes to what would tantamount be a restricted transfer otherwise, and we'll get to that a little bit as well a little bit later. So let's move into Articles 26 to 28 in focus. If you do remember the DIFC Data Protection Law of 2007, very, very similar heading and wording here is that basically we talk about transfers out of the DIFC with respect to an adequate level of protection. And we talk about transfers out of the DIFC with respect to the absence of an adequate level of protection. So an adequate level of protection for personal data leaving the DIFC basically just means that there is equivalent, similar controls and safeguards and expectations around handling of and the law that supports the personal data in the jurisdiction that it is being transferred to. So obviously internal transfers within the DIFC, no issues, but because it's protected by our data protection law. But if you have data leaving the DIFC to another jurisdiction, if it is considered adequate, and we'll talk about how that's determined a little little bit later and tell you what that adequate means for us. If it's to one of those jurisdictions that's recognized as adequate and it has those safeguards and controls in place, then it is going to be considered a protected transfer and it can go ahead without any further ado. Transfers out of the DIFC in the absence of an adequate level of protection, however, are something where you have to take more considerations into account. There need to be additional mechanisms. It may be fully restricted if you can't apply one of these mechanisms. And it essentially means there is no data protection law or equivalent data protection law in the destination place for processing. So even if there is, for example, a data protection law in that destination, there is going to be a question around how the data protection law is implied, enforced, whether it is the same or equivalent to our data protection law, and whether or not we can trust that it will offer the same protections and the same legal and judicial backing that you get in the DIFC. So that's effectively what those articles cover. And as I said, you'll recall that those articles were also in the law of 2007, but we've updated them to include more details and more information about what those mechanisms are and how to apply them. We've also removed permits altogether for transfers out of the DIFC. So that's something that you want to bear in mind. If you had a permit in the past, it's no longer valid. You have to come up with a different way of applying the law correctly to your transfer mechanism. And that really comes down to accountability. We thought that basically accountability, well, it's one of the factors. Accountability is important in determining your data protection compliance and taking responsibility as a controller or a processor for the type of processing you do, even when you do it outside the DIFC. So with a permit in place, it seemed as though there was a possibility of only relying on that permit, which was meant to be for one certain type of processing. It ended up being applied, we found, to all processing outside of the DIFC. And so we've removed it and asked that you evaluate your position if you had a permit before. We haven't been granting permits either since January, quite frankly, because we thought it was unfair to charge for a permit that we weren't sure would be in place for very long, depending on when the law got enacted. And then Article 28 covers data sharing with government authorities in particular, and we can touch on that very, very briefly later. But I want to spend a little more time now on Articles 26 to 27. Now, I'm moving on to the slide. Bear with me. I really hope that it works. We have a presentation that you may have seen out there already, but I think it's worth running now. It's about 2 minutes long, and it features Dino Wilkinson from Clyde & Co., who is also on the call with us and will be answering questions later or along the way if you like. But they very, very kindly put together a number of presentations and series of video clips to help better understand the Data Protection Law 2020. So I'm going to attempt to run this one now. Bear with me. As I said, if it doesn't run, we will go ahead and move on with the presentation. I might ask Dino to briefly touch on what is in here, but let me give it a try. Oops, I have to go back one now. Okay. Hopefully you can see this. Try sharing one more time. I will share. There we go.
No voice here.
Okay, sorry, I've been told that you can't hear the sound appropriately. So what we'll do, we'll move back into the presentation and we'll go ahead and share that later. Sorry about that. I was hoping that it would work, but unfortunately, sometimes technology doesn't cooperate with us. In any case, yes, I will most certainly share that presentation with you all at another time. So let's go ahead. I'll re-upload what I was sharing. And Dino, are you there?
Yeah, I'm here, Laurie.
Do you want to just kind of cover those bits and pieces that are in the presentation, or do you prefer that we just share it separately?
Yeah, you can share it. I mean, it's a shame it wasn't. It was such a great video.
It is. It's a very good video.
I'm joking.
It's going to be in the slide deck that's shared around as well. That link is a hyperlink, so you can definitely get to it anyway.
Okay. I mean, yeah, we were just talking about the various options for DIFC entities to transfer data outside of the DIFC, making the point, I think you've already said, that you've got those various routes to transfer, to export data outside of the DIFC, and that's to any jurisdiction. So that includes sort of onshore UAE, the different routes in terms of making sure that's lawful, which have included, whether the jurisdiction is on the approved list by DIFC, or if not, using the standard contractual clauses, or other sort of mechanisms. But I'm sure you'll go through all of those now. So.
Yep, absolutely. So let's move on. Well, basically what I wanted to show you this time around, and hopefully this works as well, but we've posted guidance and assessment tools on some key topic areas of the DIFC data protection law, this being one of them. So you can see the DIFC data protection website hyperlink here. That is our general data protection website, and it'll show you all of the other links that you can take to see our guidance page, our forms and fees page, and so on and so forth. So this is a clip from the guidance page that shows you how to find the data export guidance. And then in terms of our assessment tools, you have the data protection assessment tool, which is on data export and sharing. And again, I'm going to attempt to share that. I think that's going to actually be doable this time. But just give me a moment to unshare this and get back to the guidance site. Again, bear with me just briefly while I move into that. But it's hopefully going to help you work through the issues that come up the most with respect to applying your knowledge of data exports for the DIFC. So give me 2 more seconds. I'm going to upload this now, and you should be able to see, hopefully, the tool. Can someone confirm, Dino, can you see the tool? Is it being shared yet?
Yes, I can see that now.
Okay, perfect. Great. Well, that one worked. Good. So this is our data export and sharing tool. It gives you links into the law itself here, and then it gives you a good explanation of, for example, what data export sharing means, that it defines third countries or international organizations as being the places that you're sharing the data with. For our purposes here, we've referred to only a third country, just to keep it simpler. We've got this special note about Privacy Shield that is also available on the data protection website. But, and that we are not allowing Privacy Shield only on the basis that it's a mechanism between the US and the EU, but that you want to, or that we never have really, and now that it's been invalidated, it's not really an issue, but that you need to reevaluate your position with respect to whether or not other parts of your business use that. But again, we'll touch on that a little bit later. So you have some nice information here that gives you updates and feedback about data sharing generally. and then we go through the tool. So for example, are you processing personal data that will be transferred to a third country, i.e. a destination anywhere outside the jurisdiction of the DIFC? Quite simply, if you say no, the survey ends there. You submit and you are told, for example, that no further action needs to be taken. So as I said, for example, if you are transferring within the DIFC, your processing only appears to be taking place in the DIFC, then you are fairly safe. We have a few provisos for you, but the transfer can go ahead. Now, if we look at this again and we say, are you processing personal data that would be transferred to a third country? Yes. Then it asks you the next question, which is, does the third country destination provide for an adequate level of protection, which we've touched on? You can say yes. Again, that's where it ends. And so this is helping you ask the questions of whether or not you understand where your processing takes place. These are all things that are exactly as they are set out in the law. And you can then determine whether or not your processing is in line with the data protection law. So for this one, for example, if you say that you are transferring it to a place that has an adequate level of protection, fine, you can move on from there. It will tell you that your transfer can go forward and no further action is taken because it complies with the law. But it's best practice to confirm the nature of such transfers outside the DIFC, and whether or not it's in writing, you can determine for yourselves. It's probably best practice to state that again in your contracts or in your policies and whatnot, that you only have transfers to adequate jurisdictions, for example, maybe a company policy that you set out. And ensure that you update your notification to the Commissioner's office so that we know what's happening with respect to your transfers. So that's that one. I want to show you the last sort of process that you can ask here, starting again with, yes, you're making a transfer, but this time the answer is no, that you are transferring it to a jurisdiction that does not have an adequate level of protection. So then it asks you, are you processing the data in accordance with Article 27, which handles transfers in the absence of an adequate level of protection? All right, and so this tells you what those three basic options are, which then break down into other portions of Article 27, namely Article 27.2, 3, or 4. So if you say yes, again, the quiz ends and you get this information, which is copied basically directly from the law. It's just broken down into a very concise table that helps you understand what the things are that you can use to ensure that your transfer is compliant based on one of the appropriate safeguards, derogations, or limited circumstances set out in the relevant portions of those sections. So you will have already assessed this, hopefully, but it gives you a good reminder that, okay, I'm transferring to a jurisdiction that does not have adequacy, but I do have one of these things in place as set out in the law. So you have legally binding instruments between public authorities. That's probably not going to apply to a lot of you, nor is binding corporate rules, quite frankly, because there are a lot of companies that don't have them yet. It's the norm to not have them, and it's a set of policies and internal rules that have been approved by the European Commission. But if you do have that kind of thing in place, if you have binding corporate rules, you can let the Commissioner's office know, and we can run through them and ensure that we're happy with them. It won't be a long 18-month process to 24-month process that it normally takes to establish binding corporate rules. It'll just be a review by the Commissioner's office that they're in place. Or standard data protection clauses, which are the most common form of appropriate safeguard that's applied when you're transferring to a jurisdiction that's not adequate. We have these available for DIFC entities, adapted from prevailing ones in Europe that we've made applicable for DIFC entities. So it should be fairly straightforward to be able to use them. I will again allude to a proviso that under the Schrems 2 decision, the standard data protection clauses may be under review. So watch the space and check our forms and fees section to make sure that you're using the most up-to-date ones for DIFC. Again, if you are using similar forms already, the EU model clauses, for example, in your contracts because you have a more global presence, you're a multinational, I'm certain they will be more than sufficient. If you'd like to talk to us about it, and make sure that you're doing something that is compliant with our law, though, because you're not using the DIFC ones, but you are using the EU ones, that's perfectly fine as well. But I can say with 99.999% certainty that if you're applying the EU model clauses, you're more than compliant with our law. You can also, use clauses from another jurisdiction if they exist, if they're already recognized, for example, as adequate with the DIFC or the EU. You have approved codes of conduct and approved certification mechanisms. Those aren't really popular yet. We don't have any kind of accredited entities for certification mechanisms yet, but we're willing to talk about these things and figure out where we can make those apply. So right now, quite honestly, your best option is the standard data protection clauses for transfers outside the DIFC if you are not transferring to an adequate jurisdiction. Likewise, this list of derogations tells you all the different options there for transferring outside the DIFC to a non-adequate jurisdiction. The data subject has explicitly consented, or it's for the performance of a contract with the data subject and the controller. The transfer is necessary for reasons of substantial public interest. So this is most often used, for example, when a public authority like another regulator or an AML or a sort of financial crime regulator has asked for information about a data subject or a group of data subjects that needs to be transferred outside the DIFC. You could potentially, see using this as a derogation. It's necessary for the establishment of a legal claim or for the vital interests of the data subject. And the transfer is made in compliance with applicable laws and data minimization principles. There are a number of derogations, and we don't have to necessarily go through them all because some of them are fairly niche and uncommon, but it's good to know that they're there. And again, they shouldn't really be the ones you rely on the most because it's quite difficult to keep relying on consent, for example, or to be able to justify substantial public interest every time or establishment of legal claims and so on. It's much more concise and safer to usually just go with one of the appropriate safeguard options, even though it seems sometimes like we're running out of options in that regard as well. And then in limited circumstances, again, this is something that you want to apply very, very sparingly, but there is an option under the law for transfers to non-adequate jurisdictions where the transfer couldn't be based on anything else, where the you have confirmation that the transfer is non-repetitive, covers only a small number of individuals, is necessary for purposes of compelling legitimate interests, with a documentary assessment behind it and so on, and that on that basis of the assessment provided suitable safeguards with regard to protection of personal data. So that's running through very briefly all of the kinds of things under Article 27 that could allow a transfer to go forward to a jurisdiction or a third country that is not recognized as adequate. But again, you want to examine that pretty closely with respect to what it is your entity does, where it sits in the grand scheme of things with respect to the rest of your organization, what transfers it's responsible for, and make your decision based on your own business's needs as to how you're going to comply with Article 26 and 27 of the data protection law. And again, as always, update your notification so that we're clear on what what's happening there. And you can basically announce it to the world more or less by way of our public register, because that information gets recorded on our public register. So that's our assessment tool. And hopefully by running through that, we've also run through what our possibilities are for data sharing. I'm going to, while I'm transitioning here again, I have a few hands raised and comments. Dino, you have your hand raised. Did you want to say something?
Yeah, sure, Laurie, if you don't mind. I was keeping an eye on the chat, and I just saw a couple of questions about adequacy and what determines an adequate jurisdiction.
Okay.
Which is obviously a jurisdiction deemed adequate or determined as adequate by yourself, by the Commissioner's Office, and then I believe you've got the list of adequate jurisdictions is up at the moment, and I think we've included in the new law, which wasn't in the original law, that a sector or a sort of a subdivision of a jurisdiction could be deemed adequate as well. So potentially, if there's a sectoral law in a specific country, that might be adequate. But I think that was answering that question.
Yeah. So going back to this slide, as you said, so in terms of Article 26, an adequate level of protection means something that is basically equivalent, similar controls, similar safeguards as you would find in the DIFC. And as I said, we're getting to how you determine adequacy if you're interested in that. But where there is no adequacy, again, if you look here at the explanation of Article 27, it's essentially where there's no data protection law or no equivalent data protection law in the destination place for processing. So even if, for example, as I said before, there's a data protection law in place, but it's not equivalent enough. It's not substantial enough in the sense that it provides protections for the data that's coming from the DIFC in the same way that our law would protect it. That means that it's not adequate. Okay, so just moving ahead to what adequacy means, just to get into the details a little bit more. This is an excerpt here directly from the law, saying basically that for the purposes of Article 26.1, the Commissioner may determine from time to time that a territory is deemed adequate. And we would take into account the following factors. And these are similar sort of across the board with respect to other data protection laws as well that have this concept in them. But basically we would consider, for example, the rule of law, general respect for individuals' rights and the ability of those individuals to enforce their rights via administrative or judicial redress, that they have access, how or what type of access the public authority has to personal data. So if public authorities have unfettered access and it really is very unlimited or unrestricted, such that it would really negatively impact the data subject's rights, then that would mean that would factor heavily against the adequacy of that law or jurisdiction. We talk about the existence of effective data protection law or any data protection law at all, but mostly, obviously, an effective one that, again, draws similar parallels with respect to our data protection law. It includes rules on onward transfers, so it doesn't just leave the DIFC, but there's some sort of acknowledgement of what happens after it leaves the DIFC. The independence and competency of a sitting data protection authority or supervisory authority that has enforcement powers in that jurisdiction is another piece that we consider. And then international commitments and conventions binding the third country and its membership of any multilateral or regional organizations. So making it sort of stick, as it were. This is the law is binding. There's international commitments between entities, between jurisdictions, I should say, so that it's clear that the law would be enforced by those jurisdictions. So DIFC recognizes nearly all jurisdictions that the European Commission recognizes, plus Abu Dhabi Global Markets. There is scope for further adequacy decisions based on the factors that are outlined in this excerpt of the law above. The Commissioner uses these factors, obviously, because it's in our law, but also we're guided by how the European Commission makes its adequacy decisions as well. There's something called the adequacy referential that we're guided by, and it includes further details than what you see in this excerpt here, but it helps us determine, you know, how does that authority make decisions? Are we convinced that they are enforcing the law that exists in their jurisdiction appropriately, and so on and so forth. So basically, with respect to our adequacy recognition, you can go to our website, as I showed you earlier. Oh, we have just guidance there, right? So if you go to our data protection website, which is here in this hyperlink, so that when you get this slide deck, you can use this link to go straight to our site. You can see under there is one of the blocks is called adequacy jurisdiction. So you can just link straight to it. Right. So with respect to UK and Brexit, the Commissioner's Office communicated in March of 2019 that we'll continue to recognize the UK post-Brexit. And we're working with the DCMS, which is the UK Department of Culture, Media and Sport, which is where the Data Protection Authority of the UK sits, which is called the ICO. We're trying to engage with them in order to get adequacy recognition by the UK of the DIFC. Currently, the DIFC is not recognized as adequate by any jurisdiction. This we want to change and make it a little bit easier for our entities in the DIFC to be able to exchange data, at least starting with the UK. You know, we have a lot of entities that have UK parents or UK associations, and having that mutual recognition would make our lives, I think, a little bit easier here in the DIFC for our businesses to be able to exchange that data. And it would be the first time in the GCC that a jurisdiction is recognized. As I said, we don't have adequacy recognition, but nowhere else really around here does either. So I'm just going to briefly check back on the chat and see how we're going. I think there were possibly a few more hands raised. Give me just a moment,
Laurie,
please. Go ahead.
Yeah, it's Dino here. Just going to say on the point on adequacy, obviously ADGM recognises DIFC, and as you mentioned in your slide, you've recognised them, so there is mutual recognition there. But a few people have asked about the UAE, which is obviously a separate jurisdiction, doesn't have its own data protection law at the moment, so not strictly recognised as an adequate jurisdiction by yourselves or ADGM.
That is correct. Yep. We do not recognize the UAE as an adequate jurisdiction, nor does ADGM, for precisely the reason that Dina stated. There is no data protection law, no national data protection law at the moment, even though there are certain laws in place that have data protection like elements to them. We are waiting for a data protection law to come from the UAE to be able to then evaluate whether or not we would recognize it as adequate. I'm going to, while we had a moment there, thank you, Dina, that gave me a moment to pull up our adequacy webpage. I'll share that with you all now so you can see just what I'm referring to. So adequate data protection regimes and centers in EU countries are listed here. You have Austria, Cyprus, Finland, etc., all of the EU countries. Obviously, as of December 31st or January 1st, 2021, we're going to have to move the United Kingdom to another section of this page, but it will still be recognized as adequate. We also list the European Economic Area members, and we list other countries and jurisdictions that have been recognized by the European Commission as well, and that's where the United Kingdom would end up. So, and as I said earlier, we have our note here on Privacy Shield as a transfer mechanism. There are questions as well around standard contractual clauses as a result of the decision that I mentioned before, this Schrems case. But let's go ahead and start talking about that now. As let me get my slides back up here. And I will go into the Schrems discussion. So, right. So with respect to the Schrems decision, very, very high-level summary of the issue is that international transfer mechanisms such as Privacy Shield and standard contractual clauses did not provide, in his view or his organization's view, sufficient protections for rights of EU data subjects. So what that means basically is that there was a mechanism previously, way back when, in the early days of data protection in Europe, called Safe Harbor. That was an agreement between the European Union and the United States for transfers to the United States. And it was only about those transfers. That was invalidated in 2015. You may all remember that if you were working in data protection then, or compliance, or just generally in your legal team. That was invalidated, which means that you couldn't use that as a mechanism anymore for those transfers between the United States and Europe. And then about, I don't know, 8 or 9 months later, Privacy Shield replaced Safe Harbor. And everybody had until, I think it was August 31st, 2016, to change their mechanism or subscribe to Privacy Shield if they wanted to, or simply forget any of those mechanisms and use, for example, the standard contractual clauses, or decide to use binding corporate rules. But they needed something quite immediately. So binding corporate rules wasn't always an option. As I said before, it takes quite a long time to get those approved in Europe. And basically, in the end, a lot of people either subscribed to Privacy Shield in 2016, or they went with the standard contractual clauses, which everybody might also know as the model clauses. And then there was a follow-up case, this case called Schrems 2. So that first decision was Schrems 1. This is Schrems 2, and it reached its conclusion in the Court of Justice of the European Union on July 16th. The key takeaways here is that, well, first, when you're using the standard contractual clauses, we understand that further investigation into the security and safeguards of the destination jurisdiction will be required, and that Privacy Shield can no longer be used as a transfer mechanism between Europe and the United States. So what does that really mean for everybody here? Again, if you're part of a large multinational organization, you might be part of a company that uses Privacy Shield or used Privacy Shield until July 16th. In that case, transfers from the DIFC to Europe that would then go on to the United States would have to be reevaluated. Any transfers really from Europe to the United States have to be reevaluated in terms of how they will apply the new, or I guess pre-existing mechanisms that were available before that they might not have ever used, so would be new to them. This will obviously, in most cases, be the standard contractual clauses. But again, if the standard contractual clauses are up for review, or you have to actually apply a mechanism in terms of double checking the jurisdiction that the data is going to, it gets a little bit more cumbersome. There has to be an assessment that's made, and really, it starts raising questions about, is there any mechanism that is acceptable to be able to send data outside of the European Union? And since we track in the DIFC, a lot of the guidance of what the European Union and the UK uses, we might be looking into applying the same sort of legal conclusions to the use of model clauses in our law for our transfers. Right now, we're staying stable. We're not changing anything right now about the standard contractual clauses that are posted on our website. Again, that's under forms and fees. And if you need to apply them to your transfers outside of the DIFC because you don't have any such mechanism in place, fine. But as I said before, if you are in an organization that is using the EU model clauses, these may also come up for review by the European Union. They certainly are under review for revision anyway by the European Commission, and they'll have to take account of the Schrems II decision, just how much revision they'll make and the further requirements that will be added to those model clauses. You can use them again in the DIFC. They're based on the same model clauses, our clauses with the European Union ones. So please just double check what you're doing with respect to your transfers outside of the DIFC. If you're just using the model clauses as a group from Europe, that's absolutely fine. As I said, the UK has its own set of model clauses as well, which is again based on the same ones. It all kind of comes back to the same place. It's just you have to have your legal team and a compliance person or data protection officer or what have you making assessments as to exactly what mechanism you're going to land on and how you're going to apply it, and that you're all happy and comfortable that you're compliant. For entities that don't have any of those affiliations with Europe or what have you, but need to just apply the model clauses because you transfer data on the mainland, you're a smaller outfit, you're a medium-sized company just here in the UAE or maybe just in the GCC, you need to consider the applicability of the DIFC model clauses only, most likely. But again, this isn't legal advice that we can give you necessarily. It's just some tips, hopefully, that help you understand, your obligations under the law. So again, DIFC law only applies, and you don't have to worry about anything else because you're, a local retail company, for example, or something similar that only deals with processing data outside of the outside of the DIFC to a small extent, for example, just in the mainland. The DIFC model clauses are sufficient. Anything else, you probably have a whole team of lawyers working on it for you already anyway. But that's basically a summary of where we land with that. So just a few more bits and pieces around the portal. We've updated the DIFC client portal to reflect all of these changes, including all of the changes around transfer mechanisms. So just basically all you have to state is that you are transferring data outside the DIFC and what parts of the law apply to it. You can't, again, apply for any sort of permit, but we do ask you what jurisdictions you are sending the data to and that you have prepared the appropriate compliance requirements around that. Then, as always, we're happy to take questions. We hope that you use our consultation options or that you want a voluntary supervisory visit. We can come sit down and chat with you and help get you on the right track with respect to the type of processing you're doing and offer some suggestions or recommendations. Again, we can't give you legal advice, but we can, tell you our expectations. But I would say, above everything else, just review what your business does with respect to processing personal data in the DIFC and whether you use controllers or processors or work with them outside of the DIFC. That in particular, you're going to need to look at in terms of updating contracts, using the appropriate clauses to protect the processing once it leaves the DIFC to a jurisdiction that is not adequate. And if it does leave it to a jurisdiction that is adequate, you may want to document that as well, as I said earlier, whether it's in policies or contracts or what have you. And that's it, really. I mean, there's our information as to how to get in touch. You can go through the registry services team for help. And otherwise, yeah, we look forward to hearing your feedback and getting any questions. I think now we can probably open it up to questions if anybody has any. So please go ahead. I think I need to probably look at the Teams call to see what we've got and stop sharing. Right, so there's a few questions in the chat I'm going to try and pick up. All right, so 2 seconds. I'm going back to the top. Good. Yeah, okay, still somewhere way at the top. Okay, so just generally, there seem to be some groups of questions again around how do we determine if a third country is adequate. I've shown you our adequate jurisdiction list. And we've answered whether the UAE classifies as a third country. It is a third country, but it's not considered adequate. So you have to employ the safeguard mechanisms that I talked about. For DIFC entities that already obtained permission to transfer to inadequate jurisdictions, are they required to submit a new approval via the portal? Yes, you should go in and update anything that isn't up to date. If you've already said what jurisdictions you transfer to, but you had a permit in the past, your permit doesn't apply anymore. We haven't, as I said, approved permits or given any permits for at least the last 6 months, only because we didn't want to unfairly take a fee for something that wasn't going to be applicable anymore. But if you haven't notified us previously, you want to update your record to say what those transfer mechanisms are or which jurisdictions you're sending to and so on. It's pretty clear in the portal how to make that change. But if you do need assistance, the registry services team is there to walk you through it. As we said, again, the data protection laws of the UAE, there are no data protection laws in the UAE. There are only a few sort of references to data protection in certain internet-based laws or policies. There's some security requirements, cybersecurity laws, but nothing that adequately covers data protection in the sense that we're looking for. But they are working on it. The UAE is, as far as we know, putting together a national law, but we don't know when that will come out. Yes, the table under discussion is on the DIFC Commissioner's website, on the data protection website. And again, we've, I think, answered that as well with respect to what's recognized as adequate and that the UAE is not recognized as adequate. Let's keep moving on because I think we've answered that as well. For specific legal advice, Sanjeev, around the single family office who are not doing commercial activity and only have 10 employees, well, employee data is personal data. You're processing personal data anyway. It doesn't necessarily matter what type of office it is. It doesn't matter what the entity is. It doesn't matter what type of activity you do necessarily in terms of commercial activity or investments or what have you. It's not about any of those things. What it's about really in terms of data protection law is, are you processing personal data in the DIFC? Are you an entity that's established here? And are you processing personal data? The Clause 6 that you're referring to, Article 6, Clause 4 about commercial connection is only with respect to household or domestic processing. So you share your calendar of your, kids' sports activities with your husband. That is domestic processing. It's not that type of commercial activity that we're referring to. If you're an entity established in the DIFC, then that's where the law applies to you. So let's see. Question here on whether we need to consider if data is being sent from the DIFC to an inadequate jurisdiction and it will be sent back to the same inadequate jurisdiction. I'm not sure I understand that one. Sorry, let me try to read through that again. So prior question should be read as, what about Bahrain? Is it recognized as adequate? I see, okay. Bahrain is not recognized as adequate. It's not on our adequacy list. And so if you have data coming to the DIFC for processing from an inadequate jurisdiction, and it will be sent back to the same inadequate jurisdiction. Yes, once it comes into the DIFC, same as in Europe or the UK, for example, they follow the same suit as well, that if it comes into our jurisdiction, it then becomes DIFC data effectively, and the entity in the DIFC is processing it or processing it in the context of the DIFC entity's processing. So yes, once you send it back out, you probably should be considering safeguard mechanisms for that data. I know it seems questionable, but it is logical in the sense that we are hoping that by applying the same sort of requirements, you are then safeguarding DIFC data, what effectively becomes DIFC data within the jurisdiction. I don't know, Dino, do you have a different take on that, or do you want to offer any kind of support on that one?
Yeah, no, I agree with you, and I think yeah, if data comes in, then regardless of where it comes in from, once it goes out, you have to follow the transfer rules of the DIFC for that personal data. So yeah, in the case that's referenced in the chat, if it comes in from a jurisdiction that hasn't been deemed adequate, then you'd have to figure out a mechanism to get it transferred back. On a separate point, I mean, I saw the question asked about Bahrain. I mean, there is a lot. I mean, that's just a sort of perhaps a reference to the fact that there is a new DIFC. There's a new data protection law in Bahrain. We've also had one published in Egypt as well in the last couple of weeks. And I think this is a region where there are a lot of new data protection laws. But just the fact of a jurisdiction having a data protection law doesn't mean it's yet been assessed as adequate. But yeah, I think that probably means that the situation is quite potentially will fluctuate over the next few years. So the point of determining whether something is adequate is the decision made by the commissioner, and that's the latest information published on your website.
Yep. Perfect. Thanks, Dino. That's absolutely right. There is a lot of activity around data protection law in the region, and I know there's a lot of stuff to get your arms around when you have companies or affiliates, branches, or what have you in the other parts of not only the GCC, but of the world. I mean, you have to consider all the data protection laws that apply. What we hoped to do with the DIFC data protection law, though, because it aligns with the UK, Europe, Australia, New Zealand, Japan. I know I sort of run through a similar list every time you probably hear me talk, but I do that because they're either jurisdictions that have similar concepts and principles underlying them, like Australia, for example, or South Africa, but haven't been recognized necessarily by the European Commission, or they are recognized, and so we know that they have regimes that are similar to ours and to Europe or the UK. So that is something you want to consider, is basically if you're applying the laws of places like that, Canada, Europe, UK, any of the ones that I mentioned before, our own law, obviously you're applying, you're going to be very, very, very well along the way to being compliant generally, and probably employing mechanisms that will help you transfer the data. But you need to definitely pay attention if you're just working and processing in the DIFC to how you're transferring data outside the DIFC. And again, if you're applying something similar to European standards, it's very, very likely going to be acceptable under our standards. It's just that we have this mechanism there if you don't do any of that at all. And we really do hope that local companies, the smaller to medium enterprises that are solely in the DIFC and the GCC are starting to think about what needs to be done. Because I think, again, this is a developing area. You're going to have to think about it anyway at some point, especially if there's a national data protection law that you may have to consider as well. So it's best to get that underway already anyway for your own purposes. So we're getting questions about other parts of the law, really. I'm happy to talk about them separately if you want to try and email separately. With respect to, for example, there's a question about conducting an annual assessment. There is a form on our webpage that you can look at that is under the forms and fees sections. With respect to some of the other questions that are coming up, I think they're very specific ones that you're probably going to have to get some legal advice about in terms of who's a controller, who's a processor. We will have separate sections on this as well anyway, though. with respect to this question, is DIFC providing any direct or indirect consultancies to understand or answer one specific queries? Again, we can't give you legal advice necessarily, but we're providing plenty of data in terms of guidance on our website. So hopefully you can check the guidance, use the assessment tools that I provided previously, and you can, ask any questions that you have after that, or start formulating some ideas about the direction you want to take with respect to your compliance. I'm going to give you one more word, Dino, if you want to wrap up. But I think there are a couple other questions that are coming in that if you keep sending them through the chat, I'm happy to try and address as many as I can. Just one last thing I wanted to say in terms of expectation, in terms of evidence of safeguards in place. Again, you can show us the employment of model clauses or our standard contractual clauses on your contracts and your processing and transfers outside the DIFC. So, Dino, over to you. Any last words that you wanted to add?
I think just in terms of, the subject today has been the transfers of data outside the DIFC or exports of data. And it is, I think, you and I will acknowledge that it's one of the tricky areas of the data protection law. It's not necessarily an easy concept to understand, and there's quite a lot of different routes through. But essentially what it's intending to do is to make sure that if you are the controller entrusted to look after data, that, when you send the data outside the DIFC, so outside the legal regime that protects it here in the DIFC, that you're doing something to make sure that data is still protected. And that's why, the first step is does that country have an adequate level of protection itself? As the Commissioner decided, that country is adequate. If it has, that's fine, that it's protected by law in that country. If not, then you need to look at other routes to making sure that you're applying protection, and that can be a contractual route, like the model contractual clauses, or some other route or derogation in the law. So that's the kind of high-level thinking. I always like to sort of step back on this particular question, because otherwise we run through, we get risk running into quite a lot of different avenues and talk about adequacy and all of those different questions and assessments. But at its basic principle, it's about making sure that the data is protected, and that's consistent with the obligations around sort of governance and accountability that are in the law.
Brilliant. Yep. Thank you, Dino. Yes, it is very tricky. Hopefully, if you go through the assessment tool and you do some reading of the guidance and answer the basic sort of checklist type questions that we have set out, and you start getting your head around exactly what Dino said, it's either a question of the place I'm sending it to is going to provide the same sort of safeguards as DIFC, or the place I'm sending it to doesn't. It's that basic starting point, and you can start making some decisions about your transfers there. So thank you, everybody, for your time. We will be running these sessions again, and it will be recorded and sent to everybody, and we'll be also adding these slides to our guidance page as well. But we have to wrap up at this point. And again, I really appreciate your time. Please do let us know if you have any questions, or if you do want to engage in consultation, about the type of processing you're doing, or if you need our assistance in any way. And also, if you'd like a supervisory visit, we're always happy to come out and sit with you as well. Thanks, everyone. Have a good afternoon. Thank you, Dino, for joining us. Really appreciate your input.
No problem. Thanks, Laurie. Thanks, everyone.
All right. Take care. Bye-bye.